welcome to the BHBA Immigration Section CLE on Investor Visas. My name is Maggie Stewart. I'm the co-chair of the Immigration Section, and we're here today for a great CLE on Investor Visas. This presentation will provide an overview of Investor Visas, including EB-5 Investor Program, as well as E2 Investor non-immigrant visas, with insights on how to make sure your clients have a realistic expectation about the entire process. My co-chair, Joanne Litt, is going to introduce our speakers today, and we're going to dive right in because we have a great packed program that will take place over the next hour. One little housekeeping matter. Sorry, Joanne. Your CLE certificates will be emailed out to you within 24 hours, and the slides that will be shown during today's presentation were already emailed out to you, and they're also here in the chat. So if you'd like to download them, you can get them out of the chat as well. Over to you, Joanne.
Okay, great. Our first speaker will be Brodie, and she is the co-chair of both the immigration practice and the EB-5 Immigrant Investor Services practice at Fox Rothschild. She represents companies and individuals in business immigration, employer compliance, and EB-5 matters. And Michael Clark is our other speaker. He is a seasoned corporate attorney with nearly 2 decades of experience advising U.S. and international businesses. His practice centers on corporate governance, commercial transactions, financing, EB-5, immigration, investment, mergers and acquisitions, and securities. And I also wanted to note that the international section is co-sponsoring our session today. So we can jump right in, Ali, go for it.
Great. And you should be able to see my screen now, and we're going to go through the slides. So hello, everyone. Thanks for having us. It's nice to virtually meet you. And of course, hopefully we can meet in person whenever those in-person meetings resume. But thanks for tuning in for this discussion. Again, my name is Brodie. I'm a business immigration attorney at Fox Rothschild. I co-chair the firm's national business immigration practice, and I co-chair with Michael our EB-5 Immigrant Investor Practice Group. Michael, as you know, is a corporate attorney at Fox here in Los Angeles. And for those of you that are not familiar with the firm, we are a national firm with just under 1,000 lawyers practicing across 27 offices around the country. So we're a full service firm, which makes it a nice one-stop shop for all of your legal needs. So with that, I'm going to jump right in. And we're going to talk about immigrant investors and non-immigrant investors who, really are the core of the American economy. I'm going to give you an overview of some of the different visa categories, both immigrant and non-immigrant. And I'm going to share with you how these can be used in practice in relation to investors. So the various visas that are available allow us as a country to draw on our international skill sets and people around the world. In my opinion, this is why immigration is so important in the United States. So just to give you some context for our discussion, it is important to understand that U.S. visas fall into 2 different categories. We have our non-immigrant visas, which are temporary visas, and some would say there are more than 50 categories of them when you think about the principal and the subcategories. So we're talking about our B1, B2s, H1Bs, L1s, TNs, Os, on and on and on. And then we have our immigrant visas, which lead to green cards, usually through employment, through a family member, and then of course today our focus will be through investment. And I think that a lot of people don't realize that the latest and greatest in tech development or food product innovation or a new hotel concept or scientific research, right? That's what we've been living in, scientific research with regards to this vaccine. A lot of that happens right here in the US only because we have these visa options that allow us to bring in these talented individuals and entrepreneurs to our country and help our country remain competitive in the marketplace. So the first non-immigrant visa that I want to touch on is the E2 visa. This visa is really the hallmark of investment non-immigrant visa type immigration. The E2 visa is a treaty investor visa, and therefore that means that it's limited to investors who hold citizenship of a treaty country. So currently, the E2 is not available to nationals of BRIC countries because the United States doesn't have in place a treaty with that country. The visas for a foreign investor which could be a company that's coming to the US as an owner, a manager, or an essential employee, where the investor is an organization or a company compared with an individual, and it's owned at least by 50, it has to be owned at least by 50% by citizens of the treaty country. Where the investor is an applicant who's coming to the US to develop and to direct the business, we have to show that the applicant holds citizenship of the treaty country and that they're in control of this US enterprise. So this is normally established in the filing by showing that the applicant has operational control, and this can be documented through a managerial position or through other corporate instruments. So I'm going to say just having a managerial title alone, because we see this in practice a lot, having a managerial title alone does not work in these cases. You still have to show that the applicant has control over this E2 enterprise. In all cases, we have to show that the E2 company is real, it's active, it's operating. In other words, passively investing in a real estate opportunity would not qualify, although I will say there are certain ways of structuring real estate deals for E2 purposes. The investment has to be in a commercial enterprise. That means it's producing a good or a service in hopes of generating some type of financial return. So we get the question a lot of times, can I do an E2 in a nonprofit? And unfortunately, for the most part, that does not work. In terms of the minimum investment amount, compared with the EB-5, which we'll be talking about later, there is no minimum investment amount. Rather, it has to be proportional to the type of company that's being started. So most of these will be, in my opinion, north of $100,000 investments. The business cannot be marginal, and what that means in an immigration context is that it can't simply support the investor and his or her family. It has to also employ U.S. workers. The E2 visa attracts a large number of entrepreneurs and foreign companies who are looking to come to the U.S. and gain better market access for their product or service. I would say these visas are great because the visa can be extended indefinitely. And I know many in our industry would say that this is really the closest non-immigrant visa to having a green card, still remaining in the non-immigrant territory. In practice, I can tell you I've structured many E2 investments, dealing with investments of 100,000 to investments involving hundreds of millions of dollars made by public companies abroad. This is a very popular visa. Just as examples, we use them for tech companies, restaurant chains, boutique hotel, private equity firm. We just did a nutrition company that does nutritional supplements and smoothies, art studios. So you can tell there's a tremendous amount of versatility with this particular visa category. And again, remember, no minimum investment amount, rather a substantial investment. So I think, as you can tell, this is one of my favorite categories to use with our entrepreneurial clients. So another channel that is commonly used for investment-based immigration in the corporate sense, so different than the E2, is this L1 visa. And the L1 visa is used by multinational companies for intra-company transferee. And so this is used by companies that might already be established abroad and they want to transfer a manager or a specialized skill employee to the United States. It's also used by companies that are already abroad and that they're looking to open a new office or a US subsidiary, hence this connection to investment immigration. The L1 visa is available in two flavors, as I say, the L1A, which is for executives and managers, and the L1B, which is for your specialized knowledge employees who have specialized knowledge of the company's product, service, technique. I think many in my industry would say that the L1 is quite popular, but it has become a bit more difficult to obtain over the years. And, unlike the E2, there is no limit as to who can apply for this visa in the treaty sense. And also, unlike the E2, there is, in the L1 context, a requirement to continue doing business abroad and in the US versus in the E2 scenario, we're not really concerned with whatever the business activities are abroad. I would say there's a significant amount of strategy that an immigration lawyer would consider when someone has both options on the table between an L1 and E2. In practice, just in the practice context, we see this used by, again, a large variety of companies, large and small. I think a lot of people think the Ls are traditionally used by these huge multinational conglomerates, and that's not the case. It can be used by small businesses as well. Commonly in the international restaurant, hotel area, tech, pharma. I mean, it's open to every industry. So now I want to switch gears and go through some of the immigrant visa categories that are commonly used by entrepreneurs and investors and foreign-owned companies. And, you know, when we think about immigrant visas, maybe we think that the E2 entrepreneur wants to stay in the US permanently to continue developing their product, or maybe a software engineer who created a technology needs to stay here permanently to continue their collaboration with US companies. So on this slide here, you can see some of the different ways that someone can get an immigrant visa, meaning someone can receive that green card or immigrant visa through sponsorship. And today we're only going to talk about the employment-based sponsorship, and then within that, even just a few of the categories. So on this slide, you can see the various employment-based or EB categories. You can see they go from EB1 through EB5. I'm only going to touch on some of the categories within EB1, and then we're going to primarily focus the rest of the time today on EB5. So the EB1A is the sister immigrant visa category to the O1 visa. This is really for individuals of extraordinary ability. And in fact, they can self-sponsor here, which is unique, meaning they don't need a US employer to sponsor them. And the applicant has to show in tremendous detail with an extreme amount of supporting evidence that they satisfy at least 3 criteria. And I'm going to share those with you on this next slide. We have done EB1As for the obvious candidates in the entertainment world here in Los Angeles and New York, but also for others who you might not consider qualifying for an EB1A, or even think about this in the investment immigration context. So obviously we have our entertainment EB1As, you have your EB1As for someone who maybe architected a unique software. We've done them for heads of security for a large nightclub chain. And in the immigration context, we've done them for very unique cases. So maybe you have a philanthropist who's known around the world, who qualifies for an EB1A, and they can self-sponsor by making an investment to continue their philanthropic activities in the United States at likely a much lower cost compared with the EB5, and much faster processing times probably compared to the EB5, which we'll talk about shortly. So there's unique ways of looking at the EB1A in the investment context. The EB1C is the sister immigrant visa category to the L1A. So many times if you have a multinational company that's invested in the United States to set up shop here, and they've sent an executive here, many times the company or the individual would like to stay in the United States on a full-time basis. And so in that context, we would seek out the EB1C green card. Again, EB1C compared with EB1A. EB1C requires sponsorship by the employer. EB1A doesn't necessarily require employer sponsorship. And so now I want to give you just a high-level overview of EB5 before I turn it over to Michael. And we're going to spend the rest of the time today just on this EB5 program because this is really the only green card category that's 100% designed around an investment immigration. So here in Los Angeles, there's a ton of EB-5 projects really all around you. And I would also say that there's a lot of good information and bad information. There's a lot of good actors and bad actors. And so hopefully we can provide some clarity as to what this program is and probably more importantly, what it isn't. So the EB-5 category is the immigrant investor category, and this is the other EB category that allows self-sponsorship. So no need to find a US employer here. I can be a foreign national, choose to make an investment, and essentially self-sponsor. Probably most importantly is to note that there's been a lot happening, or maybe some would say not happening, in the EB-5 world. So in November 2019, among many changes, the minimum investment amounts increased from $500,000 to $900,000 for investments that are in a TEA, which is a targeted employment area, otherwise known as an area, a rural area, or an area of high unemployment. And then they changed from $500,000 to $900,000 for TEA investments, and from $1 million to $1.8 million for non-TEA investments. Through the EB-5 modernization regulations. So then fast forward to just a couple months ago, on June 22nd of this year, a federal court ruling in Northern California resulted in the restoration of the prior investment amounts. So bringing it back to $500,000 for TEA investments and $1 million for non-TEA. So they essentially knocked down this EB-5 modernization rule. And if that excitement was enough, all in the same week, on June 24th of this year, the EB-5 industry, unfortunately, I would say, was dealt a huge setback when one senator objected to the EB-5 Reform and Integrity Act, which was a bipartisan bill, mainly centered around protecting investors and bringing some integrity insurances to the program. So the objection to the bill prevented it from being passed before the Senate went on recess, which essentially has resulted in the lapse or expiration of this regional center program as of June 30th. So just to be clear, as of today, the EB-5 Regional Center program has yet to be reauthorized. There is a tremendous amount of support for this program, and it seems that it hopefully will be reinstated, we're thinking, within the next month or two in some form. It also seems unlikely that USCIS is going to try and reinstate the higher investment amounts of $900,000 and $1.8 million until Congress reauthorizes the regional center program. So we're kind of sitting in a window right now where we have the lower investment amounts of $500,000 and $1 million, but we don't have a regional center program to invest in. So what that means is, as of today, only the direct investment amount option through the EB-5 program is allowed. And the only reason that it's still open is that that is a permanent program that doesn't require continuous reauthorization by Congress. And so we are seeing clients who are taking advantage of the direct investment route, which historically has been a lot less popular, and pursuing these investments at these lower investment thresholds. So I just want to give you that background. We're going to spend the rest of today really focused on this regional center program. Historically, that has been the primary vehicle used by EB-5 investors, but I want you just to understand what's available today, what's not, and what the options are. The EB-5 program itself, again, includes both the regional center and the direct, but understand that this is a job creating program, meaning the whole purpose of this is that the investor has to create 10 full-time jobs per investment. And, when we think about EB-5 in the entrepreneurial sense, I would say this is very popular with our entrepreneurial clients. Many will choose to make an EB-5 regional center investment, then come to the United States, and then separately they'll start their own company on the side. And many prefer this route because they don't then have to run their company pursuant to the rigid restrictions or requirements associated with the EB-5 program. And of course, we have others who will choose, maybe they're already here on an E2 visa, they have their E2 business, and maybe they'll choose to increase their investment in that company and pursue an EB-5 green card that is anchored by their E2 business in the country. So both are great options. Both require very close counseling with immigration attorneys, and for reasons that you will talk about moving forward, the Regional Center program has typically been favored for investors to come here and be able to kind of do what they'd like to do while they're in the country. So it is important, I think, for people to understand what drives the appetite for project owners and for investors, because that's really what allows us to use both of these options within the EB-5 category. And so from the project owner or principal or developer, however you want to title them, from their perspective, this is typically utilized by a US developer who's looking for EB-5 investor capital as an alternative source of financing, because maybe it's cheaper capital. And I think Michael would agree, but most people, we hear a lot of rumors out there where people are saying, well, it's free money. But I would emphasize to you that there's nothing free here. And it's not even easy money, but it's just maybe cheaper capital in the sense that the interest rates are a lot lower. Generally, mezzanine financing is more risky, therefore more expensive to obtain. And so in the EB-5 world, typically we'll see much lower interest rates. And typically, you'll see these utilized by real estate projects of some sort. Now, from the investor's perspective, the foreign investor, they're interested in this program because they get to make an investment and they get a green card in return. The investor invests their capital into a project. They don't have to live in the same city, state, region as the project that they invest in. And one investment yields green cards for the entire immediate family. There's no requirement that the investor works in the US, so they can come here and retire or do whatever they'd like. And again, remember, does not require any family or employer sponsorship to come. So they can proactively make this choice and make an investment to secure their green card. In terms of the amount of capital that can be raised, I would say, remember, there's no set amount of capital that has to be raised to qualify for to be an EB-5 project. Typically, in my opinion, to be worthwhile for a regional center, you'll see capital raises starting at several million, and they, of course, go up to hundreds of millions of dollars depending on the project needs. The amount of capital that can be raised from EB-5 investors is a direct correlation to the number of qualifying jobs that will be created. So this is not some random number. And this is largely driven by the job creation that comes from an economic report. So just so you understand, we take the total number of jobs, hopefully leaving some cushion. We divide that by 10 jobs per investor. This tells us the maximum number of investors that the project can solicit. Then we multiply that by, let's say, 500,000 or 900,000 per investor, which dictates the maximum amount of capital that can be raised in relation to the EB-5 portion of the capital stack. So what is this thing that I'm referring to, this regional center? As I mentioned, investors in the EB-5 program, they can either invest into this regional center or their own business, which would typically occur outside the guise of a regional center. And so a regional center is really just an entity, organization, an agency that USCIS, the immigration agency, designates to accept foreign investor funds. Regional centers are focused in a specific geographic area within the United States, not the entire country. So they're focused in a particular area where the project will occur and where they're going to seek to promote some form of economic growth in that area through the creation of jobs. That's really what a regional center is, and you can see some of their other functions once established on the slide. So I wanted to share with you, just so you could see a typical regional center structure in the EB-5 world. The first thing I want to point out is that investors do not invest directly into the regional center. Rather, they invest in something that's called a new commercial enterprise, or an NCE. And this is just a limited partnership, an LLC, and so forth. And this is an entity that's formed for-profit business and for lawful business activities. And, many people will think of it just as a fund. The NCE then will direct the funds to what we call the project or the job creating enterprise, JCE, which is our actual project. So maybe you can think of it as a hotel if that's what we're building, or a factory. So you can see from the slide that the NCE and the JCE are related, but the investors are not investing directly in there. And so just to simplify, the investors make their equity investment into the new commercial enterprise. Then the new commercial enterprise has an option of either making a loan to the job creating enterprise, the JCE, or the new commercial enterprise can make an equity investment into the JCE. Now, historically, the loan model has been favored, especially in markets like China, because the investor's perception of less risk, and the developer, for the most part, likes this model, so that they don't have the investors involved, I should say, meddling with their projects from an equity standpoint. There are certainly projects, and I'd say more so in the direct context, that are more equity focused. And in those cases, obviously, the investors have a chance for a greater ROI. And, some developers like that option, and some don't. So in terms of the types of projects, I listed, these are just very broad categories and certainly not limited to these options, but I wanted just to share with you some common types of projects that are utilizing EB-5 financing. Most of them are real estate centric. The reason for that is the large number of jobs that we can create through construction when we're building something versus when I'm maybe just opening a franchise unit of a restaurant, just for comparison purposes. So you can see on the slide some of the countries that typically investors come from. Again, open to everyone. I've handled thousands of these investor cases. I've traveled around the world to meet the investors with the regional centers to market to the investors abroad. In my opinion, the largest number of investors typically have come from mainland China. I'd also say that China has the largest developed infrastructure or market to support EB-5 marketing, in terms of the numerous EB-5 immigration agents. There's also a large volume from Vietnam that's developed very nicely over the last, however many years. And then in more recent years, we've been seeing more traction from India and Brazil, Mexico, and Venezuela. So before I give you an overview of the investor's process and what they have to prove to get their green card, I'm going to ask Michael to provide some context on the securities aspect of an EB-5 investment. I think many people don't realize that this is an immigration program, but people tend to forget that the investor is purchasing a security, and so there's a huge corporate securities component to this. So Michael, I'm going to turn the microphone over to you, and you can tell me to advance your slides.
Sure, you can go to the next slide. Nice to meet everyone. So you may be wondering, why is the securities lawyer here? And I think Ali did a good segue into that. And that is, she gave a little bit of the history of the program, where it came from and where it's heading to. And I'll tell you that when it started in 1990, and then it was expanded in 93 to include the regional center, I don't think that this was a great source of capital for developers. And so the program didn't take off immediately. And as such, it was more of an immigration program, like Ali said, and there was no clear focus on the fact that when you have an NCE, which is either a limited partnership or an LLC, selling, interests, equity interests to investors, that these are actually securities. And when the financial crisis of 2008 occurred, and capital was hard to find and developers were looking everywhere, it caught on and became a really cheap source of capital for these property developers. And, the program has always been a little rife with fraud. And I think that when it took off and people focused on the fact that these were securities, they realized they needed to bring in securities lawyers and treat it as such. The laws that come into play, the basic one is just the federal one, which is you're dealing with a security, and unless you can find an exemption, you need to register it with the SEC because it could be considered a public offering. What's less on people's radar is also, because a lot of these laws are preempted, are the blue sky laws. Every single state in the United States has its own securities laws, and depending on how you structure the offering, they can come into play as well. Go to the next slide, Allie. So I think when the program started and people looked at this, when they finally realized that it was a security, they also realized that what these developers were targeting were foreign investors. And the question arose, well, does the SEC or does the state securities regulators, do they care about non-US citizens? And there is a wonderful exemption, federal exemption called Regulation S, which everyone glommed onto, which provides that as long as everything occurs out of the United States, you don't really, if you structure it properly in your offering documents, you don't really have to worry about the SEC, or because there's no need to protect outside investors. That's not in their wheelhouse. But the two basic conditions that were applicable to any offering under Reg S was everything has to be offshore. You can't have people signing documents in the United States. And there can be no directed selling efforts into the United States. So you're totally focused on outside of the United States, finding foreign investors, not foreign investors who are in the US. Go to the next slide. And the way that the program had morphed, it was started out with everyone thinking Regulation S was fine, but in order to find the large number of investors that were needed to fund a lot of these projects that took off in 2008 and 2009, you needed some selling efforts to be occurring in these countries. And as Ali mentioned, most of these offerings were initially going to Chinese foreign nationals. So what happened was these developers would hire migration agents who would go into China, and they would, try to find investors who were interested, who could afford to put up the money, create the jobs and get a green card for them and their family. And so the question arose twofold. Is the Regulation S exemption good enough anymore if you have, these directed selling efforts that the way they were structured, they could be online, they could be accessible by people in the United States. So as a backup, there's another exemption, not Regulation S, it's called Regulation D. And Regulation D is the codification of just the basic concept is if you're not having a public offering, you just have to file a form, and you don't have to worry about filing with the SEC. And we're going to give you some guidelines to go ahead and make sure you're doing it the right way. And so one of the big things was people would structure it as Regulation S and a Regulation D being the backup. But around the Jobs Act, which happened around 2012, and it was implemented in 2013, the SEC was trying to liberalize some of their rules and made the decision that it doesn't make sense anymore for small issuers to be hindered from using general solicitation. So we're going to go ahead and make it where, if you jump through these hoops, you can actually have general solicitation as well. And that was attractive to a lot of people in the industry because it's covers basically where you don't need a Regulation S or the first part of Regulation D. You're just covered if you go ahead and take these extra steps. And I'll go ahead and explain what those extra steps are down the road. So Ali, go to the next slide. Okay, hopefully you can see it. This is just a comparison of what is known as Rule 506B and 506C. These are the rules under Regulation D, which is now the most common exemption. As you can see, any issuer can use it. There's no limit on the size of the offering, as long as you don't have any, quote, bad actors involved, which is basically people who have been committed securities fraud in the US. And as long as you keep it to a certain amount of accredited investors, you can go ahead and have this exemption apply, which will also preempt all of the blue sky laws. The wrinkle here is that if you're going to use the general solicitation, which is highlighted in yellow, then you need to go ahead and take an extra step to verify that all investors are accredited investors. And what's interesting is also what most people don't know is actually Regulation D, as long as you keep it to accredited investors, which all these offerings do, technically you're not required to furnish any written information to investors at all. And what people in practice realize, though, even though you're not required to, it is certainly best practices to go with a full-blown private placement memo, because you are offering these securities to foreign nationals who normally don't speak English and don't understand. So the written information becomes even more important. All right, next slide. So the debate these days is which exemption should I use? The standby from about 2008 on was go ahead and do a concurrent Regulation S and Regulation D offering. And that was for the reason that if you screwed up the Regulation S and you either had directed selling efforts or you had somebody signing documents in the States, you'd have something to fall back on. But now that there's so much rampant general solicitation by the migration efforts, there's a movement among securities practitioners in the EB-5 area to go ahead and take the more conservative position and just say, let's do a Rule 506C for all offerings, and that would be the one where you could go ahead and have general solicitation. All the blue sky laws would be preempted, and you would just have to go ahead and take that extra step of verifying the accredited investor status. Next slide. So because we're talking to a group of California practitioners, I wanted to highlight, not to get too much in the weeds, but if you go ahead and do a Regulation D offering under 506C, you don't have to worry about blue sky laws because they're clearly preempted and you're covered whether there's general solicitation or not. The wrinkle in California is California has a very similar securities law exemption called 25102F that is very similar to Reg D, but it does not have a similar exemption to Regulation S. So you're in California, if your project is here or your headquarters here, you're kind of stuck going ahead and doing the Regulation D equivalent because the way the word offer of securities in California is defined, anything that originates from California, even if it's all directed to foreign nationals, if it's managed from California, you're going to have to be worried about complying with the securities laws, and the cleanest is to just do it under the Reg D 506C exemption. Next slide. So this slide just summarizes what I just said. It really is the only attractive option and gets us to the point where if you're stuck where you feel like to be comfortable, you only have one option, what are the extra burdens that you have to use in a Rule 506C offering to ensure that you're only going to accredited investors and that you take the reasonable steps to verify their status. Next slide. So in terms of EB-5 purposes, we're dealing with individuals, and for accredited investor status, you have to hit one of two main thresholds, and you can qualify under either. The first is the net worth, or the joint net worth is $1 million or more with your spouse, or an income threshold, which is $200,000 or $300,000 with your spouse for each of the last 2 years. And under most Reg D offerings, you just have the investor go ahead and give you a representation. They are an accredited investor. You rely on that and you move on. But if you want to take advantage of this general solicitation, which would preempt California blue sky laws and give you the most solid exemption under the federal laws, you're going to have to go ahead and take this extra step. So, Ali, go to the next slide, and I'll describe that there's 3 steps to verifying accredited investor status. The first is net income, which is basically you ask the investor to go ahead and produce their records from the IRS that showing their income and a representation that their income is going to be at the same level for the next year. The problem is that's great in the United States, but where you don't have a U.S. taxpayer, which in the EB-5 space is mostly the case, is that they don't have IRS forms. But what the SEC has made extremely clear is there is no exclusive way to verify either the net income or the net worth standard. They're pretty liberal. So if you are reviewing tax forms from their local jurisdiction, as long as they have to be honest, like you have to be honest to the IRS, the SEC will accept them. Next slide. And the next one is the net worth. It's the same type of invasive question you have to ask. If you're going to be saying you have a net worth of X, I'm going to need to see bank statements, brokerage statements, consumer reporting agency reports. And here you run into the same issue if you're dealing with foreign nationals, is they may not have access to the same, U.S. documents and credit reporting agency reports. But again, the SEC is going to take a very liberal approach to, as long as you can get, reasonably comfortable that they have the net worth, you're good on relying on that. And the next slide is probably the easiest way to comply and deal with your prospective investors is you just ask them to go and find a written representation from a third party that you can rely on. And that's generally either their attorney or their CPA. And the SEC has said, if you want to rely on foreign attorneys and CPAs, we're totally fine with that. And they've come out strongly saying that they take a really favorable review of using these third-party service providers. There's even been one or more in the EB-5 space that securities attorneys have gone out and formed, software companies that can go ahead and assist you with this. But that is really the most non-invasive and easiest way to go. I think that's it, Ellie.
Thanks, Michael. So now we're going to focus more on the investor and their process and the documentation or requirements that they're looking to satisfy when they make an EB-5 investment. So the investor generally first makes their equity investment and they file their I-526 petition. The government is USCIS, I should say, is currently estimating between 2.8 to 6 years for I-526 approval. If the investor's priority date, which is something we could spend a whole nother hour discussing, that if their priority date is current at the time the I-526 is approved, Then they move on and they file for their immigrant visa stamp abroad to come to the US as a condition, and they receive a conditional green card, which is valid for 2 years. And so one of the reasons that we're talking about 6-year processing times is because there is a significant backlog in these cases. And if you have an investor who is from mainland China or Vietnam, and I think mainly mainland China at present, it could take them many, many years before their priority date is current, meaning many, many years for them to secure that conditional residency and then move on to the next phase in this process. And that's simply because there's a huge interest, or historically has been a huge interest in the program by citizens of these countries, and they have, therefore exhausted the visa numbers available. So now they're in a waiting line. Now, once the investor's I-526 is approved, they obtain their visa, they come to the US as a conditional resident. Prior to the expiration date of their conditional green card, which is valid again for 2 years, they have to file an I-829, which is just a petition to remove conditions on their residency. And if approved, they would get a regular green card that's valid for 10 years. And they can continue to renew it. They could look at options for seeking US citizenship, but essentially at that point, they're out of the EB-5 program. And just for timing considerations, the 829 current posted processing times, I believe, are somewhere between 2.5 to 5 years. And so that doesn't mean that the investor loses status during that time. They still maintain their status, and they have to continue to, if they want to travel abroad, get stamps to go abroad and come back and so forth. But they're still in permanent residency status while the 829 pens. So, all to say, this is a very long process for the investor and for the project. They're going to be involved with each other for many, many years. So it is a big commitment on both sides. Now I'm going to share with you, very high level, I'd say, an overview of the investor's requirements, because this is really what drives us as counsel, right, in terms of how we prepare these petitions, both from an immigration side and from the security side. So the first requirement here is very simple, right? They have to invest in a new commercial enterprise, which is just defined as an entity that's created on or after November 29, 1990. The second requirement is that the investor has to make an investment from a lawful source of funds. And the amount invested, again, we touched on this earlier, depends on whether that project occurs within a TEA or a targeted employment area. And if it's in a TEA, it qualifies for the reduced investment, which is currently $500,000 and pre-2019 was $900,000. We'll see what happens in the future. And if it's not in a TEA, then we're looking at the minimum investment of $1 million or $1.8 million. Now, in the regional center context, most of these projects are in a TEA, and the investors therefore can invest at this lower investment threshold. I'm going to touch on lawful source of funds in a minute or two, but note that the TEA, the concept of who determines the TEA has reverted back at present to the pre-November 2019 rules, which means this is largely for the states to make that decision. Things changed for a short time under the EB-5 modernization regulations, but right now we're back to the old rules. And so not only does that include the lower $500,000, $1 million investment, but it also includes going back to TEA designation. There's a number of other changes, but those are, I think, the two that are most interesting and directly facing to an investor. On the TEA concept, we get a lot of questions about when is the TEA determined. So what happens if I invest in a project that's in a TEA today, but it's not tomorrow, right? Because there's an economic boom in that area or whatever changes. And so just remember that the TEA is determined at the time of the investor's investment or at the time of their I-526 filing, whichever is earlier. And in practice, in many cases, the EB5 investors' funds are held in escrow until the 526 is approved in some cases. And so in those situations, the filing date of the 526 would then lock in the your TEA designation. Now, the third requirement is that the investor has to make an investment that is at risk. And in the most basic terms, what that means is that if this project fails, the investor can essentially face losing their entire capital contribution and the immigration benefit, mainly the green card. So all investors in an EB5 project have to have a chance for success and for total loss. I think explained another way, the EB5 regulations do not allow for any guarantees to the investor, no redemptions, no property in exchange for investment, no creative side agreements. I'm sure Michael could tell us lots of stories about what he's seen. And you can Google, and these are all, all over the internet. So, we have to make an at-risk investment, no promise for me making my investment as an investor. The fourth requirement here is that the investment has to create 10 full-time jobs. So this means that the funds actually have to be deployed from the NCE to the JCE or the project. It doesn't work just to receive the investor funds and let them sit on reserve at the NCE. The job calculation here is really where I would say that an EB5 regional center option differs from the EB5 direct route, meaning in your own business. In the regional center context, we can count indirect jobs, which are easy to think of as those construction jobs, which might last for less than 2 years. And we can count direct jobs, which would be, if you think of a hotel, these are your receptionist, bellboy, hostess, and so forth. These are your full-time employees. Versus the job calculation in the direct context, we're only looking at counting direct jobs. So these are your direct full-time W-2 employees. And so I think you can see in the regional center context where we can count these indirect jobs, we can get a jobs output number that is much greater. And that's really what allows these EB5 regional center projects to the ability to raise so much more capital. Now, the last requirement is that the investor has to be engaged in the active management of this NCE. Very high level, this means that it can't be a passive investment, but we know that it's acceptable for the EB5 investor to be a member of an LLC or a limited partner where they have the typical rights under the Uniform Limited Partnership Act, just as an example. And so I want to spend just a minute here touching on investor source of funds, because this is really what can make or break a case. Any investor 526 case has two components. One half of that filing is documentation to show that the project itself is eligible as an EB5 project and it meets all of the different program requirements. And the other half is the investor's source of funds. And this is not just a statement from an investor. This is not something that's simple. This can be thousands of pages. And if the government can't make a determination that their funds were invested from a lawful source, you could be denied on that aspect, even if the project itself is EB5 compliant. So, I would say, from my standpoint, this is really the most challenging aspect of it. Again, my personal opinion is that I think it's the most fun part of this as a lawyer. But, this is where the investor has to show every single penny or whatever currency, where it came from, how it moved, how it got converted, and then ultimately how it was invested into this project for EB5 purposes. So again, the analysis can be thousands of pages long. Counsel does need to be very familiar with currency restrictions that exist in certain countries, like in China and Vietnam and in India, where they regulate the export of their currency. We have to be familiar with local practices. So maybe you have to understand that in certain countries, currency might be kept in gold instead of utilizing a traditional banking institution. Or if it's a real estate-based investment where the investor is sourcing their funds from real estate, maybe we need to understand that in certain countries, the property is not actually owned. The investor has a lease right, or maybe there's unique tax ordinances in that particular jurisdiction. So I would say, there's definitely an art to working with investors and documenting this source of funds. And we could easily do a whole seminar just on source of funds, but I put on the slide just a few common categories of sources of funds just to, whet your appetite. And these are really the most common sources of funds used by investors. But again, it's not rigid to those that are listed on the slide here. So I guess with that, I know that we'd like to thank you for attending this session. And, of course, the information that we provided is very high level. Every single category, especially EB-5, has a whole laundry list of other requirements, but hopefully we were able to, offer you this overview. And please don't hesitate to reach out to either of us via phone or email. We're, more than happy to answer any questions. And with that, I'm going to turn it back to you.
Allie and Michael, thank you very much. We've got a few questions and I'm going to try and we only have a few minutes, so I'll be very quick here. There was one question about somebody in EB-5 when it comes to set up, so it was making an investment into an EB, like making the EB-5 investment and then coming and setting up their own company separately. Can you just kind of highlight that quickly?
Sure. Just to clarify, so if you were to do an EB-5 investment through the direct investment route, you would then be required to set up your U.S. company and run it pursuant to the requirements of the EB-5 program. So the point that I was making is that we have a lot of clients who will make an EB-5 investment in a regional center. Something that's already set up, right? And they just make this investment and then they come to the US. And once they have their conditional green card and they'll set up whatever their true entrepreneurial pursuits are, completely independent of EB-5. That way they can run their company the way they want, and hopefully they're confident in the entity in which they invested for EB-5 purposes.
And no restrictions on having a separate investment altogether from their EB-5 investment.
No, because once you have a green card, in the United States, you're allowed to do most things, save maybe run for president. So
another question that we had was about where do legal fees tend to fall for a sort of a standard EB-5, although I'm sure there's not really a standard EB-5 application.
I would say there's really no standard that I would be able to share. It largely, if we're working on a direct deal, it depends on how complex it is. Are there more? Is it a joint venture? Or, in a regional center, are we counsel to a regional center, or does the regional center have proper counsel that's created what we would call a 526 template, or are we having to create that for the investor or create other documents? So everyone's pretty different.
Sure. Maybe an easier way to come at it is to ask when somebody retains you to work on an EB-5, what's the timeline typically from when they're starting conversations with you to when they're issued a priority date?
So from an EB-5, from an investor standpoint, because that's different than if a project's coming to us. So from an investor standpoint, it depends. If we're working with a great migration agent overseas that we work with, we can have a case put together and out the door within the same week, right? If they've already compiled all their source of funds documents. If there's, I work with a lot of one-off investors who are coming from Switzerland or Brazil or whatever it might be, and they don't have an immigration agent. And so in those cases, if they haven't contemplated their source of funds, it could take months for them to start putting together that documentation. So most of them, I'd say, are, within a month or two. Yeah.
And so once they've compiled their documentation and they have identified a project, it's still like up to a 6-year delay, I think you were saying, on priority dates, or does it?
Correct. So
it doesn't matter from country to, does it differ from country to country?
Well, the priority date differs. That's based on the visa bulletin, guides that decision. That's not something that any lawyer has any control over.
Sure.
But from the time that we file their petition to the time their 526 is adjudicated, meaning hopefully approved, that time varies. USCIS is supposed to be processing these in based on priority date availability and not necessarily on the first in, first out, which was the policy that they had previously used. So maybe someone from Switzerland or Canada, their process might be much faster than someone who files a 526 out of China, India, wherever.
Okay, all right. I think that's all the questions that have been dropped into the chat. And I know you had a hard stop at 1:30, Ali, so we appreciate that you were able to go over by a minute or two.
Sure.
Very comprehensive overview. Hopefully, maybe in the future, we can pick off a time to do an even deeper drill down on some of the more complex issues. And so we thank you for your time and for sharing all of your knowledge with us. And we hope that you have a great weekend. For all of the people who are watching, the materials were posted and emailed out. And also a video will be available through BHBA in the future if you want to share this with your friends and colleagues.